I really just want somebody who's going to aggressively fight for me in court. Is that too much to ask?
Filing my cases shouldn't be that difficult. There's got to be an easier way.
Nothing frustrates me more than having to wait for my attorney to call me back. I need them now.
What I really need from my law firm is someone who can provide my staff training so we actually can stay out of trouble.
When you have property management problems, we have your solutions. This is the Zona Law Group podcast with the experienced attorneys from Zona Law.
And welcome back to the Zona Law Podcast. I am Mark Zinman with Zona Law, and today I am truly honored to be joined by Professor Ilan Worman of ASU Law School. Good morning, Professor.
Good morning. Thanks for having me on your show.
It truly is an honor. It's the only way I can state it. I will tell you, for our viewers, the majority of my family are all attorneys, and I don't think any of them has as impressive a resume as you do. So I want to intro that to our viewers so they can understand what we're dealing with. And I do not mean to offend my family and fellow attorneys as I say that. But you are a current professor at ASU Law School. Is that correct?
Yes, sir.
All right. And for our viewers as well, previously you also worked as a clerk and appellate for the Fifth Circuit. Is that correct? For the federal bench?
Yes, for Judge Jerry Smith in Houston, yeah.
You also worked, I assume, at a law firm as well previous to that?
Three and a half years at Winston and Strawn in D.C., and it was actually a lot of fun. But being a law professor is definitely my calling.
Yeah, so. It's a good gig. There's no question about that. And as a law professor, you publish books. You publish in law reviews as well, correct?
Yeah, I've got two books, both by Cambridge University Press. One is called A Debt Against the Living, An Introduction to Originalism, and the other, my new book, is called The Second Founding, An Introduction to the 14th Amendment. And then I have a case book that just came out on administrative law. So I guess, does that count as a book? So
yes,
I guess I have
no question. But so it's all constitutional law and administrative law, correct?
Correct. That's my expertise. That's what I teach at ASU. That's right.
You've also been published by Yale, I believe, Stanford, Texas, University of Chicago, all of the different law journals as well. Yeah. The trick is to have really good titles to your articles, and then they'll be snatched up by the top law journals. That's good. So, I got to think about that for the podcast and use that going forward. I think for the reason today, we're going to obviously talk about the eviction moratorium, which really truly is a constitutional issue. And we've seen it over the past 15 months from Governor Ducey's order through the CARES, as well as now we're dealing with the CDC. But you have your own experience in litigation beyond just actually being a professor dealing with these issues, right?
Yeah, so I represented here in Arizona about 130 bars that were shut down by the second shutdown in July. And so I sued the governor and ADHS, the Department of Health, and the Department of Liquor on behalf of these bars. And we made a variety of separation of powers claims, a non-delegation claim, basically the statute here in Arizona, and maybe we'll get into this later some more, delegates to the governor in the event of an emergency, which is pretty broadly defined, by the way, all police power of the state in event of an emergency. And so we raised what's called the non-delegation doctrine. This is sort of separation of powers 101. The legislature makes the law, the executive executes the law, courts adjudicate cases under existing law. And a corollary of this is the legislature can't give up its legislative power in these broad and open-ended provisions that basically tell the governor, you go and do whatever you think is good and just and proper in the world. Right? That's legislative power. And so we made that claim, and we made a discrimination claim where, if you were a bar in a restaurant, you could stay open. If you were a bar in a hotel, you could stay open, right? And so we said this violated what's called the Privileges or Immunities Clause of the state constitution. And so we litigated that. I'll take some credit for opening up Arizona a bit early because we kind of forced the governor's hands. We think with the Supreme Court case, can't
well, that was the one case that was actually successful as to Governor Ducey's executive orders, correct?
Yeah, so at the trial court, we won on the issue of he shut down the bars. And while leaving the restaurants open, and he allowed restaurants to sell alcohol to go, which lots of people love, and that's great. But under existing law, only bars had the opportunity to sell alcohol to go, or legally had the right to sell alcohol to go. So what Governor Ducey did was, by executive order, again, not by legislation, by executive order, shut down the bars, left the restaurants open, and gave the restaurants the privilege that bars had, right, to sell alcohol to go. The one thing that they could have, maybe helped them survive in that second shutdown. And so we got that struck down, the granting of the off-sale privilege to restaurants. And then we got all the way up to the Supreme Court on the non-delegation issue. And a couple days before the oral argument, Governor Ducey says, okay, just kidding, opening up, all of Arizona.
That's what you want. I mean, that's what we've said, especially in our industry with, a lot of these times when it's either the legislature or the executive branch is coming out with these different moratoriums, you have to fight them to effectively enforce your rights. Because if you let it go, maybe the governor would have just allowed that to continue. The fact that you pushed the lawsuit, then the governor switches and actually you get, your rights, the bars in that case got their rights back. And I think what you're mentioning there, which is truly important for the viewers to understand, is the basics of con law, right? Of you have three branches of government. They're supposed to have very set lanes that they follow, and it's when they start going over and they delegate duties, that's where, at least in that case, that was a big issue.
Right. And for the eviction moratorium situation, there's another consideration, which is the division of federal and state power, right? It might be that the state legislature can or can't do this, but that's a different question than whether Congress has the power to go in and sort of invade this traditional area of state concern. And so that's another question we have to keep in mind.
Yeah, and that's perfect. We'll use that actually as a launching pad for where we go. I do want to say, though, that the important thing for people to realize, the disclaimer I should say, is the discussion today truly is meant to be on constitutional law, right? It's not about what my personal beliefs on are evictions or moratoriums, and frankly, I don't think your opinions in that respect weigh in here either. It truly is, what I want to gather from you is the implications, is the constitutional ramifications of these things. And so with that, you had mentioned the difference between the state and federal. And so if we look historically, last March, all of this in our industry with the eviction moratorium started off with Governor Ducey entering his executive order. Days later, the federal government did the CARES Act, and then later in the year, we have the CDC. And a lot of people just kind of think of them all blended together as one moratorium. But it really starts with a governor's executive order in the state level. You then go to a federal legislature, and then you go to the federal agency under the executive branch as well. So let's explain what's the difference between the state side of things and the federal, and who really has authority at all in dealing with these things?
Yeah, that's a great question, and we'll probably spend most of the next hour talking about this. So, stop me, at an appropriate point. But you have to keep in mind that the powers that the state legislatures have is different than the power that the federal Congress has. And both questions are different from whether the legislatures, either at the state level or the federal level, can delegate or have delegated such power to impose an eviction moratorium to the executive, to the governor, or to the president. So it's really like a matrix, if you think about it, like with four quadrants here. And so just let's put aside for the moment, right, this question of delegation, whether the CDC had the authority, whether Congress or the state can delegate to the governor or CDC this authority.
Yeah, let me interrupt real quick, just so people understand. When you say delegation, I mean, there's no question, legislature makes laws, right? And so when you're referring to the delegation, you're saying whether they can transfer that power over to either the governor or, in this case, the CDC as an agency to act and create law without the legislature, right?
Right, that's exactly right. Look, every law delegates authority, delegates power to the executive, right? The executive executes law, and so every law delegates authority to the agency to do some things. But the non-delegation doctrine says, look, there comes a point. So one question is whether Congress has in fact authorized CDC to do something, or whether the state legislature has in fact authorized the governor to do something. That's question one. Do the governor or the president actually have the statutory authority to do this? The next question is, well, sometimes the legislature delegates in such broad and open-ended terms, as in Arizona, the governor has all police power, right? That at some point, the delegation is so broad that it effectively makes the governor or the president into a lawmaker. And that's what I say violates the so-called non-delegation doctrine, this idea that, again, Congress or the state legislature exercises legislative power. They're the ones that make laws. They can't just give that up in these broad and open-ended provisions, right, that says, we want clean air. EPA, you figure out how to do it, right? At some point, it's so broad that it violates the separation of powers principle, what's called the non-delegation doctrine. That's right.
And so here, let's jump right into the meat and potatoes then. And it may be going to the end, but I know our viewers want to hear this, is CDC. You have an issue of delegation, right? And then you also have the issue of it's a federal agency. What are they doing with state law here?
Right. Okay. So let's start with the division of federal and state power. Right. Historically, I'm not clear, by the way, that the states could have done this too, because of something called the contracts, which I hope we get into. I love talking about the contracts clause. But as a general matter, okay, Congress is a body, the national government has limited and enumerated powers in Article 1, Section 8 of the Constitution. They can only exercise power specifically granted to them in the federal Constitution. And the state legislatures then have a residuum of power. The states have plenary police power to regulate the health, safety, welfare, and morals of the people. In other words, Congress has limited specific powers. States can do anything else except, if it violates the Bill of Rights or the state constitution. Of course, there are other independent limits, right? Well, the federal government, what power does the federal government have over eviction moratorium? Well, the basis of most federal power today is the Commerce Clause. That's it. If there's a spending clause, there's a Commerce Clause. Nothing else really covers this,
but
right?
Commerce
Bankruptcy,
Clause is
naturalization.
Going between states, isn't it? I mean, in the simplest form, it's business between the states.
Right. It says Congress shall have the power to regulate commerce among the states. So Congress has a power over interstate commerce. So what does this mean? First, it has to be interstate. It can't be internal commerce, right? Commerce internal to one state. And it has to be commerce, right? Historically, commerce was the exchange of goods, right? Barter, buying and selling, regulation of contracts for exchanges across state lines or just within a state to be commerce. Things like agriculture, production, labor, wages and hour law, right? Labor laws, manufacturing, these things preceded commerce. These were economic things that preceded commerce. And of course, there's a bunch of non-economic things in the world, right? That affect commerce downstream or affect the economy downstream. So historically, Congress could and only did really regulate this interstate transportation of goods, the interstate exchange of goods. It basically used this commerce power to keep trade free between the states.
Well, Professor, can I interrupt then? How is it possible that an eviction has anything to do with interstate commerce? None of my clients understand this question is, if I needed my property back, which is an apartment unit, how does that affect what's going on in New York? How does that affect interstate commerce?
Because since the New Deal, since the 1930s, the Supreme Court has completely changed Commerce Clause jurisprudence. The two key cases here are called United States v. Darby and Wickard v. Filburn, which I'm happy to discuss. But since these cases, the modern doctrine holds that Congress can regulate an activity within a state, okay, even if it's not commerce, and even if that activity alone doesn't impact commerce, right? If in the aggregate it affects interstate commerce. In other words, so let me give you an example of Wickard v. Filburn. Okay, in Wickard v. Filburn, this case from the 1940s, Congress imposed agricultural quotas, how much wheat you can grow. Well, Farmer Filburn was a farmer who grew wheat on his own farm entirely within a single state for his own consumption. For his own consumption. There was he was growing wheat for himself, but there was no commerce, let alone interstate commerce. And he was fined because he grew wheat in excess of the production quota established by Congress.
Well, let me interrupt there, though. Again, though, the issue is, one of the Texas cases. So there's been, I think, at least 4 different federal challenges to the CDC moratorium, right? One of them was Texas, and they looked at that argument because the CDC obviously raised it, and Texas said, evictions do not affect interstate commerce at all, no more than we would look at divorce. And obviously people move more from divorces than they do from evictions, and the feds can't touch divorces, can they?
Right. Well, so probably not, but maybe they'll try, and then we'll get a different answer to that question. But to just complete the circle on Farmer Filburn, the Supreme Court said it's okay that Congress regulated that because by growing his own wheat, Farmer Filburn was forestalling access to the interstate market, and if you don't buy wheat in the interstate market, that lowers the demand for wheat. And in the aggregate, if many people did this would lower the price, right? Because supply and demand affects price. So it will affect interstate commerce in the aggregate. Okay, so now what doesn't affect interstate commerce in the aggregate? As you say, divorce law, family law, property law, tort law, everything eventually downstream affects the national economy, which affects commerce in the aggregate, which is why people say today, under the modern Commerce Clause, under the modern Commerce Clause jurisprudence, what can't Congress do? What can't Congress do, right? And so it's tricky. In the 1990s, and this is going to be relevant to the moratorium analysis here, the Rehnquist court tried to rein this in a bit. And what they said is, look, Congress can't regulate non-economic activity when there are too many inferences to interstate commerce. So the famous case was Lopez, which basically Congress enacted the Guns Near Schools Act, making it a federal crime to carry a gun near a school. Well, carrying a gun, that's not commerce. That's not even an economic activity. You're just carrying a gun.
Walking down the street.
Education. It affects the economy downstream, right? But it's not commerce. It's both things historically left to the states. So the court basically said, look, these are non-economic things. And to get to the downstream effect on interstate commerce would require piling inference upon inference upon inference. Okay. So that's the lay of the land, right? And by the way, there's an important concurring opinion by Justices Kennedy and O'Connor where they're like, look, the reality is the judiciary, the courts created this expansion of congressional power. They legitimized, right, this expansion of federal power. So we, the courts today, should at least look to traditional areas of state concern and protect it. You know, maybe Congress can do everything under the commerce power, but we should carve out certain parts that were historically reserved to the states, sort of inverting the traditional limitation on Congress's power. Congress has all the power it wants, but will, specifically look at certain things historically left to the states or historically within the state's power, and those will protect. So that's the lay of the land. Well, how do we do an eviction moratorium? Suppose Congress enacted a statute saying there shall be a nationwide eviction moratorium. Can it do that? Well, I mean, is an eviction moratorium, are evictions economic activity? Are they non-economic activity? I mean, it's kind of tricky. Entering into a rental agreement, that's economic, okay? But when someone refuses to pay you and you want to evict them, is that an economic activity?
It's just property owners getting their rights back, isn't it?
Right. Oh, yeah. Well, even if, okay, fair enough. But even if it's economic activity, again, where do you get to the connection of interstate commerce? Okay, so the inference has to be people who are evicted will then travel. Okay, traveling is considered commerce. Okay, but you'd have to think that they travel across state lines. And if they traveled across state lines, that they would stay in some setting where they're likely to spread coronavirus. Again, that's not economic activity, I don't think. Someone would have to get coronavirus. Again, that's not economic. That person would have to be affected by coronavirus. That's not economic. And then they would have to be, that would stop working. Okay, that's economic. And then in the aggregate, if enough people got coronavirus as a result of people moving across state lines, in the aggregate, and stopped working, in the aggregate, that would have a downstream effect on commerce.
Isn't that too many inferences to get to that? I mean,
exactly. That sounds like piling inference upon inference upon inference upon inference, right? And I just want to be very clear about this. The transportation of persons across state lines is commerce. Okay, traffic in persons is commerce. So if Congress wanted, it could pass a statute that says before you cross state lines, Congress can set up checkpoints along all the highways and say you must take a rapid antigen test before we allow you to cross state line. It could do that. It could do that because that is commerce. Okay, but to regulate eviction moratoriums, right, you have to conclude that in the aggregate, this will substantially affect commerce, right, somehow, or the refusal to or not imposing this moratorium. And I just think to get to a downstream effect on the economy, to a downstream effect on commerce, requires several chains of inferences at any point of, that it's somewhat tenuous, right? And so I don't know, that's how I would have thought.
But that's the problem. So if we're going back, I mean, it was the CARES Act basically in March of last year, which was done by the federal legislature, not an agency, but the actual federal legislature that passed the CARES Act. Now, the CARES Act said you can't even file a lawsuit. You have no rights whatsoever if you have a federally backed mortgage or you participate in any federal program. Then comes the CDC, which is obviously a federal agency. So not only do you have a delegation issue, you have the federal versus state issue. I mean, it's almost too many things. So that's the case what we're dealing with right now, which for the viewers that don't know, the most recent case, which is Alabama Realtors, they won at the trial level in the federal court. The court, though, stayed their own ruling. The appellate court just basically upheld the stay, saying, no, the CDC order continues. And now, theoretically, this is going to the Supreme Court, correct?
Okay, so the CARES Act is a bit different. Okay, so that has to do with Congress's spending power. So let me briefly talk about the spending power, and then let me talk about the CDC itself, which relates to the conversation we just had. So CARES Act, that's not a regulation of commerce. Look, we spend money, we collect taxes, and then we can appropriate money, right, to promote the general welfare. Congress has this power to spend. Now, when Congress spends money, it can, of course, specify what it wants to spend money on, right? So it can say, we are giving states money to buy X textbooks, and we are giving states money to buy Y highways, or to improve Y highways, okay? The question is, can Congress then attach unrelated conditions to the receipt of the spending, okay, in order to achieve regulatory objectives that Congress could not have achieved directly through its enumerated powers? So South Dakota v. Dole is this famous case where Congress gave highway funding to the states, but South Dakota had a drinking age of 18. It was an outlier. Every other state had a drinking age of 21. So Congress passed a statute that says, we're taking away 5% of your highway funds unless you raise your drinking age to 21. To 21. Congress obviously can't regulate the drinking age directly. This is something reserved to the states. And the question is, can Congress condition the receipt of highway funds on the state doing something unrelated to how they're spending the highway funds, right? So the court basically said, look, any condition has to be germane. Okay, germane to the purpose of the spending program. It has to be related. And that sounds obvious, right? I mean, you can specify the kind of concrete standard that has to be used to build the highways, okay? How many lanes they have to be. All of those are germane to the spending. But is this germane? I mean, they both have the similar objective, which is increased safety, but they're unrelated. It's a different thing, okay, that also promotes safety. Having said that, the court said, oh, it's fine, it's germane, close enough. Both are interested in highway safety, so close enough. So South Dakota v. Dole
argument at best.
Insane. It's insane. I know I'm not supposed to talk about my personal opinions, but this is my personal opinion about law. Again, that just seems crazy. And Justice O'Connor again had a dissent there where she's like, "This isn't germane. This has nothing to do with how the money is spent. We're twisting their arm. We're taxing their citizens, taking their citizens' money, and then promising to give back that money if they do all of these things that the Congress couldn't impose directly."
Okay, but tie that into CARES then. So CARES Act basically said if you have a federally backed mortgage, which means you've taken a loan from the federal government or it's been securitized over to the federal government, or you participate in certain federal programs, for this 4-month, 120-day period, you can't file an eviction. You can't charge late fees. How is somebody taking out a mortgage with, Fannie Mae 4 years ago somehow giving the federal government carte blanche then to say, you know what? Your rights are gone. You can't get your possession back, your property back.
Yeah, so there's a question of germaneness, right? When you federally finance these mortgages, right, is the requirement to not evict under, during the coronavirus emergency germane to that spending? And arguably here it is germane. I think you could say, well, we're giving money for the purpose of housing low-income folks, and in a coronavirus pandemic, it's these low-income folks that need housing the most. So we require a moratorium. To my mind, actually, it's probably germane, but it might have another problem, which is that the court also says that the Congress can't coerce the states. Okay, can't coerce the state. So into doing these things, these conditions, right? And what we mean by that is 5% of highway funds. Okay, the state has a genuine choice. If it doesn't want to raise the drinking age, it loses 5% of highway funds. Who cares? Not a big deal. What if it lost 100% of highway funds? What if it lost 20% of its budget, right? So that would not be okay. That would be too coercive. Well, here. So in Sebelius, NFIB v. Sebelius, the Affordable Care Act case, this Medicare expansion, Congress basically said, look, you have to hugely expand Medicare or we'll take away all your existing funding. And the Supreme Court said, no, 7-2 said that that's unconstitutional. Well, here we had an existing program, and all of a sudden they changed the terms and say, and now you have to do this or we'll take away all your funding for your federally financed mortgages. So I think it's probably germane, but whether it's coercive, that's a stronger argument to make. Right?
I don't know the answer to this question, though, but isn't it relevant, though, that the mortgage in most of these cases would have been issued years ago, and then the law changes after that? I mean, if any property owner knows, hey, if I go to the feds, I may lose my rights, that's one thing. But for it to happen after the fact, it seems like you're just depriving people of their rights without even giving them notice ahead of time. How does that work?
That's very problematic. Historically, a state couldn't do it. I think even a state could do it today because of the contracts clause, right? There's a clause that says no state shall impair the obligations of contracts, of existing contracts. But there's no contracts clause with the federal government, I think. So the federal government can probably bait and switch you, can probably change the terms of a contract. There might be a claim, but I'd have to think about that actually. Maybe I don't want to say due process or something, but it's trickier when Congress does it. But the real issue here again would be the spending issue. Is it germane or unduly coercive? So that's the CARES Act. I'll have to think about the other thing you just raised about the retroactivity of it.
And then rolling from there, then under the CARES Act, it was the legislature. Under the CDC, which there's nobody that saw that coming, right? The Center for Disease Control, what do they possibly have anything to do with evictions? I literally sent out a newsletter when the CDC order came out. All of my clients, like, hey, a couple thousand people went out to, and I can't tell you the amount of emails telling me I was crazy and that the CDC has nothing to do with evictions and that I must have gotten something wrong. So
So this goes to the question, where even if Congress had the power to do this, which I'm not sure it does, right? But let's say it does under the Congress power. The question here is, has Congress in fact conferred that authority on the CDC? Has Congress in fact authorized the CDC to create this, right? Because the CDC, the executive, can only execute laws that Congress has enacted. So I pulled it up. Here's the statute that they're purporting to enforce, okay? The Surgeon General is authorized to make and enforce such regulations as in her judgment, are necessary to prevent the introduction, transmission, or spread of communicable diseases from foreign countries into the states or possessions, or from one state or possession into any other state or possession. So basically, do whatever you think is necessary to prevent the transmission of disease from one state to another, okay? Now, to my mind, okay, this means you can set up quarantine checkpoints, before people cross state lines. You can require health inspections. You can do all of those things, right? But if the eviction moratorium is quote unquote necessary because downstream it might have the effect of reducing some amount of people who cross state lines, then I think the CDC could pass a regulation that says all citizens must stay home for 6 months in all states. Well, if it can do that, what can't it do? It's hard to imagine things that wouldn't downstream affect this. And so that can't be the argument, because then it would be a sweeping delegation of authority, right? If that's true, it would be a huge and important power. And ordinarily, there's a canon of statutory construction that says Congress doesn't hide elephants in mouse holes. It doesn't authorize these big and important things in secretive, ambiguous clauses, right? It doesn't hide an elephant in a mouse hole, right? And if CDC has the power to do this, it has the power to order people to stay home, and has the power to do all of these things, that's kind of an elephant. It's kind of a big deal, and it's kind of a cryptic fashion, for Congress to delegate that authority. Now, look, does an eviction moratorium, can one argue that it's necessary for the prevention of the introduction, transmission, or spread of communicable diseases across state lines? Probably you can argue that. But then it's not a clear-cut case, right? And the DC Circuit, as you said, thought that this was compelling and that the government was likely to win on this issue. But here's the second sentence of that authority that I just cited you. For the purpose of carrying out and enforcing such regulations, the Surgeon General may provide for such inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles found to be so infected or contaminated as to be dangerous to human beings, and other measures as in her judgment may be necessary.
The word eviction's not in there, is that?
Exactly. Now look. In eviction, the second sentence says, for the purpose of carrying out and enforcing the earlier regulations, okay, the Surgeon General can do these things. So it doesn't limit necessarily the authority granted in Section 1, but it is illustrative. The thing that Section 1 is contemplating, right, is the kind of things to which one might want to provide inspection, fumigation, disinfection, sanitation, right? It's illustrative of the authority delegated, right? If an eviction moratorium, if none of these things is relevant to the eviction moratorium, that is some evidence that Congress did not intend to delegate such authority to the CDC. So there are good statutory interpretation arguments. It's not foolproof, because you could make an argument right? That it's necessary to prevent, especially if the CDC narrows it and says, well, only if you're likely to move to a aggregate setting or congregate setting where you might spread disease, right? I mean, so you can make an argument that it's necessary if the CDC narrows it enough, which it does. But there's a lot of arguments going the other way. I mean, the second sentence suggests a narrower scope. If the scope is as broad as the CDC seems to say, that raises non-delegation concerns. What wouldn't be covered? There's this elephants and mouthfuls canon. So there's a lot you could argue against it, but it's not a foolproof case.
Well, yeah, and the CDC actually, in one of their briefs, the DOJ came out and said, yes, under this authority, we believe we can do anything, even in the issue of fairness, which is like this broad concept that I would think the Supreme Court would look at and go, I think that's a little too much. But I guess that's the question. If it's now this case has made it out of the appellate court, they're going to go to the Supreme Court. The Supreme Court doesn't even have to take it. I mean, they can, but they could take it, decline it. How does that work at the Supreme Court level?
Yeah, it's tricky because this isn't at the merits stage yet, right? So we have the Supreme Court, we have the district court final judgment, the summary judgment, but then the district court stayed pending appeal its order, and then the DC Circuit upheld the stay that the district court imposed on his own order, right?
Which means the CDC moratorium continues until a court overturns it again.
Correct. And so why would the Supreme Court take a case in this preliminary posture where it's an abuse of discretion standard and likelihood of success on the merits standard? Now, it could do it, but it would have to be pretty bold, right? I mean, most judges during the coronavirus pandemic have not wanted to wade in on these issues until they absolutely have to. And even then they try to duck it, by saying, oh, it's moot now, right? So they'll probably wait it out and hope that it never gets to them by the time it expires. So
I can tell you, by the way, I think you're upsetting a lot of my viewers right now. I mean, I think people are hoping that the Supreme Court steps in and say, this can't continue. Because you're right. We've seen this from numerous judges just saying, we're in a pandemic. We're not addressing this issue right now. It's moot. It's not ripe for review.
I will say one thing could give your clients hope and optimism that they'll take the case, which is this non-delegation issue. So a lot of people think that the modern Supreme Court, 6 originalists, conservatives versus 3 liberals, wants to revive the non-delegation doctrine. The non-delegation doctrine, which we talked about, again, you can't just enact statutes to say, we want clean air, do whatever is good and nice in the world, right? You can't do this, but in practice, the Supreme Court has upheld since 1935 incredibly broad delegations to do things in the, quote, public interest, to do what's fair and equitable. And if those don't violate the non-delegation doctrine, what does? Well, I've written a bit about this. My suspicion is what the court is going to be doing. They're not going to explicitly strike down a congressional statute for violating the non-delegation doctrine. What they're going to do is they're going to use non-delegation as a canon of statutory construction. In other words, what they're going to say is, look, if X interpretation of the statute is correct, that would be such a sweeping delegation of power that it can't possibly be correct, right? Therefore, we're going to interpret the statute more narrowly. I think this is what the Supreme Court did in its latest non-delegation case, Gundy v. United States, which I'm happy to get into. I think they used non-delegation as this canon of avoidance, this canon of statutory construction. This CDC case is a good candidate for that, right? If the CDC interpretation is correct, then that means this delegation, right, to do what's necessary to prevent the transmission of disease across state lines would be a sweeping delegation of authority.
Open-ended.
Which would possibly be unconstitutional or likely be unconstitutional. Therefore, we're going to interpret it narrowly to say, no, this only has to do with things to which you can apply fumigation and disinfection and sanitation or something like that. So it would be consistent with what I think their strategy in non-delegation cases is going to be. But it would still be pretty bold of them to take the case, I think.
Okay, so how about, we got a couple last constitutional questions for you. Takings clause. Doesn't that come in where you have this argument, I have my property, I've given it to somebody to rent out, and they have to pay me in exchange for the benefit of living there, staying there. They don't, and you're, in the CARES Act, for example, preventing 120 days for filing a case. Under CDC, preventing the removal of the person right now, I mean, it's gone on for months. Isn't that a takings?
It's not.
Is it a regulatory takings?
It's close, but it's not. And a lot of people like takings, the takings clause. It's probably not a good candidate for the eviction moratorium. Having said that, the contracts clause is plausible, not today under current jurisprudence, but historically, this would probably violate the contracts clause, even if a state legislature did it. So we can pivot to that. So let's suppose a state legislature, okay, in its residuum of power, it has plenary police power to regulate for the health, safety, welfare, and morals. Suppose the state legislature, the one entity with actually the authority probably to do this, by the way, has not done it, right, in Arizona or elsewhere. But suppose the state legislature.
Can I stop you on that? Because that is a
Sure.
critically important point to me. I mean, you have a state governor, you have a federal legislature, you have a federal agency. None of them delve into landlord-tenant law. I mean, our landlord-tenant law come from the state legislature, right? In Arizona, we have the Arizona Residential Landlord-Tenant Act, which was created and it's modified on a yearly basis by the Arizona legislature. The one entity that we have that has not created a moratorium is the state legislature, which you'd think out of all of them, they're on the best footing to control the rights of landlords and tenants would be them. To me, even just looking at it from 10,000-foot view, the other ones all fall. The state legislature is best suited or has a legal basis to actually enact this type of sweeping legislation.
Correct. So Congress, there's an enumeration of powers problem. Maybe it's not Commerce. The CDC, it's not clear that they have the statutory authority. And if they did, that's a potential non-delegation problem. In Arizona, when Governor Ducey issued it, again, it was pursuant to this statute delegating to him all police power of the state in the event of an emergency, non-delegation problem. The only body that plausibly had this authority is the state legislature, and they didn't do it, which explains why, by the way, the executive is so strong today. Why does Congress delegate so much power to the executive? Because the legislature doesn't want to take the political heat for doing these tough issues, right? So they want to pass the buck. They want the buck to stop with the executive. They don't want to take responsibility, right? So that explains it, right? Yeah. But even if the state legislature had done it, okay, would this have been a taking, right? So a taking, basically the takings clauses of the federal and state constitutions say the government can come in and take your property, but it has to be for a public purpose, and they have to pay you just compensation for it. So the classic example of a taking is a physical taking. Someone comes in, physically condemns your land to build a highway through it, okay? That's a taking, no question. Well, what about when a legislature enacts a regulation that diminishes the value of your property? Well, the problem is every regulation has the potential to diminish or enhance someone's property, right? There are winners and losers for every regulation. Simply because you have property doesn't prevent the state from exercising its general, police powers for the health, safety, and morals of the people. When you buy property, when you transact business, enter into contracts, you assume the risk that the regulatory and legal landscape will change, will shift, which will affect the value of your investment. So as a general matter, regulations that diminish the value of your property are not takings. Having said that, the Supreme Court has said that where a regulation works a permanent and total or near total deprivation of the value of your property, that is a taking, because that's no different than coming in and just condemning your land. So there's a famous case where the South Carolina, I think, legislature stopped all development on coastal properties. And this investor had just bought this coastal property and it was now worthless. There was nothing on it. He wanted to build on it. It was a worthless piece of land. They said that was a regulatory taking. You have to pay just compensation. The question is here, first of all, the deprivation isn't permanent. It's quote unquote temporary. Now it's a long temporary.
I was going to say my clients might object to that one.
Yeah, it's BS, right? But it's plausibly temporary. It's not going to last forever. It's going to last until this pandemic ends, whenever that is. Okay, it's at some point maybe it becomes endemic and it goes away. But the point is, there's a case where Tahoe the city of Lake Tahoe put a moratorium on building. And so a building moratorium, and land developers came and said, this is a taking of our property. And the Supreme Court said, look, it's a moratorium. It's temporary. It's not permanent, right? And so it's not a taking. Even if you get out of that and it were sort of permanent, the question here is also, is it a total deprivation of your property or a near total? And it's like, well, they still have to pay rent down the line, even though we know that they probably aren't good for it, right? And so it's too hairy. It's too hairy. The real question is a contracts clause, okay? So why do I mention the contracts clause? Because even if the state legislature did this, there's a clause in the Constitution, the United States Constitution, Article 1, Section 10, that says no state shall impair the obligations of contract. Basically, you can't nullify a lawful contract entered between two people to basically eliminate the value of that contract. Isn't it that they can change, by the way, the regulatory landscape prospectively, but they can't go and say your contracts are invalid if they were perfectly lawful and valid when entered into.
If you have a contract saying that the person has to pay you rent, or you have a right to remove them to get somebody else to be able to come in, because again, I've said this on this podcast, nobody likes evictions. It's there because that is your sole remedy as a property owner to then find somebody else that's going to pay you for that. So how is that not a violation of that clause? It seems open and shut.
Well, if you're me, you're an originalist. I believe in following the original meaning of the federal constitution and the state constitutions. And it does violate the contracts clause. Not since the New Deal, very much like the Commerce Clause, the jurisprudence change, which I'll get into a second. But historically, of course, look, the value of your contracts could be incidentally affected by regulations, right? The point is the legislature couldn't target contracts specifically. So the classic example of this is the legislature could prohibit alcohol in the era of prohibition. They could ban alcohol, the use, possession, transfer, sale of all alcohol. And if you had a contract, an existing contract, okay, that for the sale of alcohol, too bad, right? It's incidentally affected. They have this general police power to regulate the health, safety, morals of the people. They can prohibit alcohol, and if your contracts for sale are incidentally affected, too bad. Okay, but like it or hate it, right? That made some sense. But what you couldn't do is target contracts, right? Here, the rental agreements aren't incidentally affected. They are the subject of the moratorium. They are the core of the moratorium. It's not incidentally affected. It's directly affected. It is what is being regulated. So historically, I think existing rental agreements subject to these moratoriums would be a contracts clause violation. That would be a contracts clause violation. Having said that, that all changed in the 1930s. Again, in the New Deal, during the Great Depression, in a case called Blaisdell, the state of Minnesota imposed a mortgage moratorium. You can't force people to pay their mortgages because they were worried about homelessness, a homelessness crisis during the Great Depression. And this would have been a classic violation of the Contracts Clause, as for the four horsemen in dissent, the four conservative horsemen in dissent, Justice Van Deventer, Sutherland, McReynolds, and I'm forgetting the other one. But 5 justices in this liberal New Deal majority said, well, it doesn't violate the Contracts Clause. Why? Well, because we're going to make an emergency exception to the Contracts Clause. We're basically going to say, look, if the moratorium is temporary, if it's made for the purpose of addressing an economic emergency, and if the moratorium reasonably addresses that emergency, we're going to say the state legislatures can do it. And since then, the Contracts Clause has basically been eviscerated.
But that's the state legislatures or the federal that would be able to do that?
So that's the state legislature did it. And because again, the state, so even if Arizona did it, it would be subject to the Contracts Clause of both the state and the federal constitution. Again, the federal says no state shall impair the obligations of contracts. But today it doesn't matter. Today they can do it, especially in an emergency. Now, if the federal government did it, it's tricky. I'd have to think about that. I haven't thought about that issue before because there's no Contracts Clause that binds the federal government. It only binds the state government. So it would be a bit tricky. There's a due process clause, but it's not clear that the impairment of contracts would follow would violate due process. It might, because due process of law says your property can be taken away from you, your liberty can be taken away from you only according to established law, which means it has to be established in advance. The quintessential violation of due process of law is when the legislature passes a law that says, look, Mark, I know jaywalking wasn't a crime yesterday, but we saw you jaywalk and we don't like it, so go to jail. Can't do that. That's a classic direct legislative deprivation of property, which is prohibited. Well, if the legislature says, we don't like what's going on, we're taking away all your property rights, for under these existing contracts for the duration of the pandemic. Isn't that a legislative deprivation of existing property? Maybe. So maybe there's a due process problem, but I haven't thought about it. It's much clearer on the state level because there's the Contracts Clause, which specifically says you can't impair the obligations of contracts.
Yeah, because I always think, to me, as an attorney, I'm sure it's the same for you, is a lot of the times I don't care what the rules are. Just tell me what the rules are, and those are the rules we'll follow. Having something change after the fact with like CARE saying, oh, because you have this mortgage, now you're subject to a moratorium makes no sense. And especially kind of like what we're saying here today is, especially if it's a federal, it's even that much farther away. Now I want to wrap up with a question that I have struggled with entirely. And it's not even you'll take it from a constitutional perspective, but think about a grocery store for a second compared to an apartment community or a property owner, because it's not just the large property owners. Obviously, we represent single family owners that, this is their retirement, and they've been stuck a lot of times being unable to recover their property because of these moratoriums. How is it, and is it constitutional, where you have this situation is they have been deprived of their rights, they can't remove somebody that's not paying for them, but you don't have that same issue in like a grocery store, right? You don't go in and have somebody say, I'm going to get my food and I'll pay you later. The government's protecting me from paying you. So how does that work? How does that comparison even fly on a legal perspective?
That is a great analogy, and I wish it were compelling to the legislatures didn't do anything, but to the CDC or Governor Ducey when they had done this, because that's exactly right. How is that fair? And the point that you raised, and I know we're trying to stay in law and outside of politics, but the point you raise is fair. Look, I own a property in Washington, D.C., where I lived when I practiced before becoming a law professor, and I'm definitely afraid that they'll just say, well, can't afford it right now, and so what am I going to do? Then I've got a mortgage that I would barely be able to pay every month, and then I can ask for forgiveness or a moratorium, which I will then have to pay eventually. Now, maybe the renters will make good on the back rent, but maybe they won't. But I'm still on the hook for the mortgage, and so it's a problem. We're not. A lot of these people aren't these big companies. Yeah, there are some big companies, but a lot of them, this is the small amount of supplemental income they have. This is their one investment. This one property that I have, and I think it's a serious issue. For some reason, the lawmakers decided that landlords are evil. Okay, I know I'm trying to get out of, I'm not trying to be too political here, but they decided someone has to bear the cost, okay, of the pandemic. Someone has to bear it. And they've decided that it should be landlords and a future generation of grandchildren because of all the debt that they're going to have to repay from all the spending, okay? And they decided landlords get the short end of the stick. What I really don't understand, by the way, is why not the bankers? Why not say, renters don't have to pay and landlords don't have to pay? Why not do a mortgage moratorium while you're at it? Because the bankers have the most money, Oh, okay, well, what about the bank? Well, the insurers are the one that pay the bankers. Well, and then we're right back to 2008, which is the problem, right? When all the insurers went belly up. So for some reason they decided that the landlords are evil, that the landlords are the ones that should be targeted. But it's just, it strikes me as unfair and also implausible.
Yeah, and that's why I think for the most of our clients, it's not about some sort of issue that they're having. If the government had just come in and paid rent right up front, landlords been able to pay their mortgage, the residents would have been able to pay their rent, and everything would have stayed. That didn't happen. I mean, even the mortgage, the rent assistance that's coming out is literally trickling out. It's not being released properly, and there's different restrictions on who can qualify for that as opposed to everybody who can qualify for the moratorium. And it does, like you're saying, it leaves property owners in the lurch. They're the ones right now that are stuck holding the bag, and I think that's the hardest thing walking a lot of my clients through that is some of them, are losing what was their kids' college, their retirements. They're the ones being severely impacted by that. But again, we'll go away from the politics. Professor, I truly appreciate you coming on today. I mean, it's just been an incredible lesson for me, for all of the viewers. So I thank you so much, and I appreciate your time.
It was my pleasure, and thanks again for having me. I really enjoyed it.
Thank you.